Hi, everybody.
Hi. Do you mind just telling us your name and your title, what your role was in today's case?
So my name is Seth Waxman. My title is Human Being. I've represented Harvard in this litigation ever since the day that Harvard was sued in November of 2014. And I was presenting Harvard's legal and constitutional arguments today in front of the Supreme Court.
How did you feel it went?
I felt like, every advocate from every side had a full and fair opportunity to explain the views that we expressed in our briefs and to discuss the evidence in the case. And as evidenced by the fact that the argument began at 10 o'clock in the morning and ended at 3 o'clock in the afternoon, I think it's fair to say that the court has given very careful consideration to the legal and constitutional issues in the case. And we're grateful for that. And that's about all I have to say. Thank you.
Thank you.
David Hinojosa and Damien Hewitt with the Lawyers Committee for Civil Rights Under Law. And
Do you mind just telling us what your role was in the case and how you feel it went?
sure, we represented, here's two of our clients here who we represented who were then students and now alumni who really exemplify the incredible talent that UNC can recruit and retain and build, building that pathways to leadership as has always been sought by the university. We represent a multiracial group of students and alumni and who have been involved, from the beginning in this case and really served important roles providing critical testimony that supported a lot of the ideas around the educational benefits of diversity that people talk about in research, but they brought some reality to it by sharing their stories with the court.
And how did you all feel it went today?
I think it went incredibly well. We always anticipate, really tough questions from the court, and it's for good reason because these are incredibly difficult issues. They're complex issues, but we think that we brought, some real satisfaction to the court in helping it to understand what a holistic admissions plan really means about how race is used or considered in a very limited but powerful and meaningful way. And it's, represents, the promise of what this country is truly about. And so we were, excited to answer those questions. But let me leave it to Cecilia and Andrew maybe to...
Yeah. Hi, everyone. It was incredible to be in the room today and to witness the arguments in front of the court, to see all the evidence brought forth, and to see the role that our testimony played in the greater picture. Really optimistic that they're going to rule in our favor. But ultimately, just incredible job for everyone who was a part of this, all the lawyers who supported us, the media teams, the other student interveners, and everyone who advocated and gathered today. It's incredible to be a part of this and to have witnessed it today.
I also want to say thank you to everyone who has poured their heart into this case, not only our lawyers, but the dozens of student activists from around the country who came to DC today to speak to the importance of diversity on campus. There's a lot of discussion about what exactly the educational benefits of diversity are. And I just want to say, as many people go to UNC to learn about civil engineering as they do to learn about civil discourse, and both are incredibly important to this country. And so I'm just really thankful for our attorneys and everyone for standing up for diverse campuses and for affirmative action. My last name is Brennen, Andrew Brennan.
My name is Cecilia Polanco, Cecilia Polanco.
Brennan. Brennen.
Not to be confused. Good afternoon. Damon Hewitt. I'm President and Executive Director of the Lawyers Committee for Civil Rights Under Law. We're so proud that a multiracial core of students entrusted us to represent them, not just today in the Supreme Court, but for several years, because we've been involved in the Harvard and the UNC cases since their inception. And we're doing this because we understand the great principles and what's at stake. We understand that the other side says that race doesn't matter. We know that's nonsense, because race matters in our daily lives. It matters for these young people, these students. It matters for everyone in our society. And for a court that has such trouble finding or addressing racial discrimination when it comes to voting rights, when it comes to redistricting and employment discrimination and police brutality, it would indeed be ironic if this court somehow saw discrimination in these holistic admissions plans, which do not involve racial preferences or demerits to anyone of any race. And that is exactly what the other side is so frustrated about. They're so frustrated that they can't find the boogeyman. They're so frustrated that they can't find the smoking gun, because in truth, they don't like the fact that race could be considered holistically. They actually want to flip the law on its head. Make no mistake, what they're asking for this court to do is exactly what the court did in Dobbs versus Jackson Women's Health, to throw out decades of precedent just because. We see living examples in our students and our clients and the hundreds of thousands who are with us and the millions throughout this country who are depending on race-conscious admissions, because race-conscious admissions speak to reality. They talk about merit. This is merit. They talk about merit. They don't talk about how test scores underpredict the talent of students of color. Holistic admissions is the only way that universities can achieve those interests, and that's what's right for America. Thank you. Damon Hewitt, D-A-M-O-N-H-E-W-I-T-T.
Oh, no.
No? Okay.
Yeah.
All right.
Thank
Thank
you.
you.
Great. Good afternoon, and thank you all for being here. And we appreciated the opportunity to present our case before the justices today. We are very proud of our holistic admissions process at the University of North Carolina at Chapel Hill. We know that every student at Carolina has earned their place at Carolina. But today was really about values. Today was about the value of diversity. It's a fundamental value that is core to our mission at Carolina, and for that reason we believe in our holistic admissions process. But you heard a lot today, we heard a lot today in the courtroom about the importance of protecting our democracy. And as a faculty member of 27 years at North Carolina and the Chancellor for over 3 years, I'm on the front line. I see the importance every day of diversity, and the importance of diversity and race being one of many factors in our holistic admissions process. This is about bringing and building a class every year of students at Carolina that will go on to become the civic leaders that we are going to count on to protect that democracy that's been threatened at times. And so, again, I could not be more pleased with the way in which our counsel, several of whom are surrounded by me today, as well as Ryan Park, who did an outstanding job in defending our case. And so, again, we will look forward to hearing the outcome in the months ahead. So, thank you.
Do you mind spelling your name for us, Chancellor?
Sure. First name is Kevin, K-E-V-I-N. Last name Guskiewicz, G-U-S-K-I-E-W-I-C-Z.
One more time.
Sure. G-U-S-K-I-E-W-I-C-Z.
Can I ask you a quick question, which is, this is a 6-3 majority conservative court. How concerned are you about what this court might do, and what the significance might be of affirmative action can't be used in the future?
I'm not going to speculate on the outcome. I enjoyed being in there today. The justices all were very engaged. I was so impressed with their questions that clearly they're giving this deep thought, just as many of us are. So we'll, again, not going to speculate, but we'll be prepared for whatever outcome we need to be prepared for. Thank you.
Thank you.
Great. Thank you.
Jen can also speak with that. I've got an errant. My locks are doing their own thing. They've got their own thing. It's okay. Good afternoon. My name is Janae Nelson. I am the 8th President and Director Counsel of the Legal Defense Fund. Today, we saw arguments in 2 cases that not only threaten affirmative action and the ability of this country to live up to its promise and to leverage its greatest strength, which is its diversity. We saw an attack on one of the canonical cases that has made this country a democracy, and that is Brown versus Board of Education from 1954, a case that the Legal Defense Fund helped to bring to victory at a time when there was state-sponsored apartheid in this country based on the subjugation of black people. What we saw today was an attempt to rewrite history, to bastardize the interpretation of this seminal decision of the court, a decision that gave this court credibility as an institution that we could rely on to guard the rule of law. And so it is not just affirmative action that is under consideration today. It is the trajectory of our future as a democracy and whether we will be one that is multicultural, multiracial, inclusive, and a beacon of what a diverse society can look like and how we can function and succeed in a global marketplace, or whether we will regress to a time period that is so ignominious that it took an entire civil rights movement and one that continues to go on today to help correct those wrongs. So we are hopeful that the court will do what is right in this case. We are very proud to represent over 25 student groups and individuals and alumni and faculty and interviewers at Harvard who stand with us and stood with us yesterday to celebrate our diversity, who are here today in front of the court to show us in real life what democracy looks like, what diversity looks like, and we are honored to represent them, and we hope that the court will do the right thing, uphold its own precedent, and uphold the future of our democracy. I'd like to invite some of our counsel, senior counsel, Michelle Turnage-Young and Jinhee Lee, to share their remarks. And Jenny Holtz.
Of course. So what's really important here, really important to all of our clients, is that talent lives everywhere. Opportunity absolutely does not. And when we have that situation, it becomes extremely difficult for our universities to identify talented students from all walks of life. It remains incredibly important for our universities to produce a pipeline of qualified graduates from all walks of life, from all corners of our nation, so that we have student bodies that give students the experiences they need to be well qualified to go forth and thrive in a multiracial democracy and in a multiracial economy. I also thought it was particularly apt that Justice Ketanji Brown Jackson pointed out that essentially what might happen here is we get another equal protection violation. We get a situation in which applicants are placed on 2 tracks. You have the applicants for whom race is a salient factor, and you have other applicants, and some of those applicants are censored. And that is absolutely not an okay outcome. Jen?
Who are you?
Oh, I'm sorry. I'm Michelle Turnage-Young. I'm senior counsel at LDF.
Do you mind just spelling your name real quick for us?
Yes, of course. It is Michelle, M-I-C-H-A-E-L-E, Turnage-Young. First last name is Turnage. That's like the word turn, T-U-R-N, combined with the word age, A-G-E. Last name is Young, like the opposite of old. And this is my colleague, Jinhee Lee.
Hi, I'm Jinhee Lee. I'm the Director of Strategic Initiatives at the Legal Defense Fund. And we have proudly represented the 25 Harvard student alumni organizations these past 4 years, from trial to the appeal to the First Circuit Court of Appeals, and now before the United States Supreme Court as amici in this case. And I cannot overstate how important their perspectives and their experiences are to this case. There was a lot of discussion in today's argument about the educational benefits of diversity and whether or not that is actually something that's substantive and meaningful. But our clients know absolutely that it is something that is a crucial part of their educational experience at Harvard. This is not something that is abstract. This is about celebration of diversity. Race is not something to be ashamed of. It's not something to be erased. It's not something that we should ignore. It's something that we should celebrate. And it is one of the strongest elements of our democracy in our country, is the tremendous racial diversity and all the benefits that diversity comes with that. And so what's at stake right now is not only what happens at Harvard, at UNC. What's at stake is what our universities and higher education looks like. And as many of the advocates said today, not only the universities, but also our society. Because as we all know, these incredible academic resources are a pipeline for leadership opportunities, for career opportunities, for opportunities to be able to make a mark on this country. And that opportunity should be open to everyone, regardless of their race. And for too long, it has been denied to people of color because of their race. To say that race does not matter in 2022, after just only 2 years ago, we had a racial reckoning that too many people have forgotten about. It was undeniable that anti-black racism continues to exist in this country. And until we solve that fundamental problem in our country, affirmative action and race consciousness is absolutely essential.
Can I ask a quick question? Sorry. I have a quick question if it's possible for today. Do you have any legal, so I'm sorry that I'll run after this. Let's get on TV to talk about y'all. But do you have a legal recourse in mind if you lose this case, given that this is a 6-3 majority case? I wonder if you're already looking at what's the next legal horizon here.
Well, we've long been looking at what other opportunities there are to expand access to equitable education in this country, and we will continue that no matter the outcome of this case. But we should not in any way concede the idea that this is something that the court can do lightly. It is bound by its own precedent. 44 years of precedent require this court to continue to allow race consciousness in admissions. And that is something that it would have to do a very thorough, significant analysis to find wrong with the underlying opinion of the First Circuit and in the UNC case as well, and also to determine how it would depart from its precedent that it is bound by stare decisis. So for us, it's never about not looking at other alternatives to expand opportunities to education, but we at the same time are holding this court's feet to the fire.
Sure. Oh, yeah. Another issue that was raised at length in today's argument is the claim by SFFA that affirmative action intentionally discriminates against Asian Americans. So it's very notable that among the 25 student and alumni organizations that we represent, that includes every single major Asian American student organization, as well as the Asian American Alumni Association, which stands united and absolutely in support of Harvard's ability to continue to use race as one of many considerations in its admissions process. And so the idea that this is a case about civil rights for Asian Americans can hardly be the truth, because the Asian American organizations at Harvard that actually represents real Harvard students, Asian American Harvard students and alumni, are unequivocal in support of affirmative action, as they have been for the past 4 years.
And we'd like to introduce one of the students who are representing in this case. Your name. My name is Jennifer Holmes. I'm senior counsel at LDF, but I'll turn the floor over to someone who's more important to this case, the actual students who will be affected by the ruling in this case. So I'll let her introduce herself.
Hello, my name's Muskan. I'm a sophomore at the college and a member of the Task Force of Asian American Progressive Advocacy and Studies. I think affirmative action is essential to a Harvard college experience in colleges around the country. I grew up in Arkansas in a very white and homogenous area where it felt like my race and my identity was something to be ashamed of. And that completely changed when I came to Harvard, because I found a college campus and a group of students who valued diversity, who valued difference. I had friends who listened to Hindi music with me. I had a friend who fasted with me for Ramadan for a whole month. And I had friends who came to South Asian events with me because they valued diversity, they valued difference, and I never felt more safe and okay in my own skin, because I was in a college campus that valued diversity, that held this beautiful diversity. And I think something that LDF wrote in our amicus brief for the Harvard organizations is that no racial group or ethnic group holds a monopoly on intelligence or talent, but some students do hold monopoly on opportunity, and I think affirmative action takes that into account and creates a more equitable society in general. And I think diversity and equity are things that we should never give up. And I'm so happy to join LDF in this fight, and I think Harvard should continue having race-conscious admissions because we require an equitable society and we require a diverse and equal America. Thank you.
Would you mind telling us your name one more time?
Muskan Arshad. It's spelled M-U-S-K-A-A-N, and my last name is Arshad, A-R-S-H-A-D. Thank you.
Thank you.
Hi all, my name is Niyati Shah. I'm the Director of Litigation at Asian Americans Advancing Justice, AAJC, and we, along with our affiliates, represented the Student Amici Plus, along with Lawyers Committee, and we also submitted an amicus brief on their